Did you want to save any time for rebuttal?
I'm sorry, Your Honor. Yes, 5 minutes, if I could.
All right.
This case arises from a personal injury claim from an automobile accident that occurred back in 2008. The complaint, the lawsuit was filed in 2010. The trial court subsequently dismissed the claim on the basis that the plaintiff had failed to comply with Rule of Procedure 1.260 by moving to substitute the estate for the deceased defendant. Now, our position is that there is an excuse, and a valid excuse for the failure to do that, and that is the misleading actions of the defendant in their response to the lawsuit. Because instead of the complaint was served on a person in Georgia who represented himself to be the executor of the estate of the deceased.
Well, let me ask you on that, Mr. Newman. As I look at the record, the summons is issued for Mr. Rogers in Indiana, and somehow or another your process server ends up in Georgia. And on the return of service, and I can't tell whether it went to your office or went straight to the court, but in the affidavit of service, which is, I think it's 042, the summary of the process server identifies Mr. Rogers as the executor, which suggests that as of February 12, 2010, plaintiff was on notice that Mr. Rogers was dead.
Well, Your Honor, in actuality, there is, of course, that document, but quite frankly, it's not typical that I would review, or that we would review the return of service if it indicated that service had been accomplished, particularly when there had been an answer filed, the affirmative defenses, discovery request, all of that had been done as a result of what we believe to be perfected service. Now,
but the answer is filed in March, which obviously postdates a return of service that suggests that Mr. Rogers is dead.
That they filed a suggestion of death, Your Honor?
No. The return of service.
Yes, sir.
Your process server apparently puts a report that says he served Mr. Edmondson, the purported executor.
Yes, sir.
Okay. I understand that then everything that happens after that is filed individually for Mr. Rogers. And as I read your brief, my understanding was that it's the suggestion of death that somehow got misfiled.
Yes, sir.
But I guess what I'm trying to figure out is it appears that as of the date of service, plaintiff was on notice that Mr. Rogers was deceased.
Well, Your Honor, yes, you're correct. But if you stand back from this and look at what happened, if in fact we had seen the suggestion of death, if that had been picked up on when it came in, nonetheless, we would have been, because of the way the pleadings came in, where there was, presumably they were acting on the basis of the correct service. They were doing their answer, they were doing their affirmative defenses. Had we stood back and looked at it at that point, even knowing the death that occurred, frankly, Judge, under the Smith case, we would have been in a situation where we would still not have had to file a motion for leave to amend under Rule 1.260, but rather just simply it was a misnomer of the defendant. Because
they weren't filing pleadings in the name of the purported executor or anyone else who was purporting to appear on behalf of the estate. They were filing them in the name of the decedent.
Yes, sir, they were, and that's part of the misleading nature of the actions of the defendant.
Well, can I ask you then, I really understand that, but if I hear you correctly, you were not aware in February of the summary of service provided by your process server?
Yes, sir.
And it through some error in your office, it was not until too late, if you will, that you discovered the suggestion of death?
Yes, sir.
So, and I know that you could get relief beyond that 90 days if there's excusable neglect. So I guess my question would be, what evidence is there in the record that there was excusable neglect?
The evidence, Your Honor, is the pleadings themselves. The fact that the responses were filed, there was never a motion to dismiss for failure to effectuate proper service. There was never a motion to quash the service. There was never, even in the affirmative defenses, it was not alleged that there was any imperfection in service. And so we acted on that belief, and even had we known otherwise, we would have still acted the same way. The only difference would have been that we would have filed a motion to correct the name in the complaint, because we had actually served the appropriate party. Now,
didn't y'all go through a mediation?
Sir?
Didn't y'all go through a mediation?
We did.
How can you go through a mediation and the defendant's not there?
Well, quite frankly, Judge, it's not unusual at all to do that, because the one who really has the decision-making power in the case is the adjuster for the insurance company. The defendant quite often is not required to show up for a mediation.
It never came up that there was no defendant because the defendant was dead?
No, sir. It never came up because the individual who was there on behalf of the insurance company was negotiating or attempting to negotiate at the mediation, and there was never an issue of liability in the case. It was a clear liability case, so there had been no real reason to go to Georgia to take the deposition of the defendant, because we were confident that we could establish liability. And the damages, would flow from that. So there was absolutely nothing done differently in this case that would have been done if the personal representative had in fact been served. There's been no prejudice. There can be no prejudice to them, because everything remains the same as if the proper person had been served. And the defense went through all of this 2 years of litigation with the knowledge, in fact, that they had known 9 months before the lawsuit was even filed that the death had occurred, and they just went through this without ever indicating in any respect that we were improperly pursuing this as we were. And I think in the cases that we've cited, they indicate that you can't just, yes, all you're required to do is file a suggestion of death, but then you can't just sit back and not disclose anything about who the personal representative is, what the state of the estate is, and just allow us to go on, or allow the plaintiff to go on.
What I don't understand is, once you file the suggestion of death, why would you file anything else? Who's the client?
Well, that's also the reason that we are misled, Judge, because how can you file an answer on behalf of a client that you don't have? How can you file responses to requests for admissions to the defendant when the defendant is deceased and has been deceased well before the lawsuit started? So that's part of the misleading nature of the actions of the defendant that resulted in over 2 years going by.
That really doesn't explain to me very clearly how I'm supposed to deal with a return of service that shows that the fellow's dead.
It's not just a suggestion of death. This goes back to the service.
Yes, sir. And the only, and I certainly I cannot, there's no way to really justify that I didn't look, or we didn't look at that return of service, except to say that, I mean, certainly it's imputed to us, but that's just not a routine thing that we look at.
Isn't it part of the plaintiff's attorney's job that when that return of service comes in, number one, you look at it to make sure that it's regular in form, and number two, you figure out, well, when's the answer due? So you know if no answer is filed, you're going to move for a default. I mean, isn't that what the plaintiff's attorney is supposed to do?
Well, yes, sir, and we do note when the service was accomplished, the date of the service, so that we know when the time begins to run. But as I said before, Judge, even let's assume that we knew at that point that he was deceased, and the attorneys for ostensibly for the defendant were filing their answers, their discovery. They could only be doing that based upon us obtaining service on the individual who they were representing. And so they were going as if we had done it.
The problem with that argument is they didn't file an answer on behalf of this Robert Edmondson as executor or whatever his name was. They filed it in the name of the decedent without any indication of any person being a personal representative or executor.
That's correct, Judge. I understand that, but the service, and this again is in I think the Smith case, the court says that, you know, even though you obtain service on the estate and you still have the name in the deceased, it's really just a matter at that point you reserve the right entity.
Of course, you didn't obtain service on the estate because this guy was not the personal representative.
But he was acting as the personal representative from the standpoint of the defense, Judge. I mean, the defense was going on the basis of what apparently he was directing them to do. And if he was acting on behalf of the estate, even though it had not been he had not been formally appointed, then when we ultimately, which we did, get an appropriate state established, then that relates back to.
He was never appointed. I mean, we don't know that he was even qualified to be this personal representative or executor for this man.
I assume he was not qualified, Judge, but we didn't know that, and as I say, in the case law dealing with these types of situations, it is recognized that as long as he's acting for the benefit of the estate, even an unqualified, unappointed individual can be, it will relate, when you actually get the proper individual served, it relates back to the actions that were taken on behalf of the estate.
Those cases involve situations where, in fact, an estate has been set up in the court. And I have Mr. Smith as the executor, and it should have been Mr. Jones.
I think Your Honor's correct. But I don't believe that is really the distinction here. I mean, I believe if an estate is set up and the individual who's acting on behalf of the estate is not qualified to represent the estate, is not qualified to act on behalf of the estate, it almost is irrelevant as to whether an estate has been set up. The effect is the same, in the sense that the estate has not, in the sense that there has not been the formality of somebody representing the estate. In this case, Judge, there was just simply no way for us to assume that no reason for us to assume that the defense was going to litigate this case for 2 years under the obvious knowledge that we were going on the theory that the plaintiff was, the defendant was alive. I mean, this is kind of a got you situation when you let somebody go for 2 years under an obviously false impression until the statute of limitations runs.
What was the triggering event that caused you to wake up to the fact that the defendant was deceased?
2 years after the litigation had begun, Your Honor, we found in a routine going through preparing for trial, as a matter of fact, because we had noticed it for trial, we were going through the file, and in the correspondence section of the file, there was the 1.5-page suggestion of death in there. When we found that, then at that point, we immediately tried to confirm that there had been an estate set up. And that's when we found that even though the will had been filed in Georgia, it had not been actually going through the probate procedure. And once we found that out, then the next question was, how do you proceed from this point? And that's when the research began as to, well, have we actually obtained service, even though it was just a purported executor who obviously was named the executor in the will and filed the will, or do we have to move to substitute? And in that regard, we have to set up our own estate, or have an estate set up by us, and then name another individual as personal
Which you tried to do in Georgia, not successfully,
Yes,
and
sir.
ultimately you did in Indiana,
Yes,
right?
sir.
Okay, so when did you file, at what time frame after discovery of this problem did you file the motion that we're here about today?
The motion that we're here on today, Judge, was the third motion that was filed. The first motion, as you might imagine, there was some consternation in the office when this was learned. And the first motion was based upon us assuming that at that point we had to establish or set up an estate. At that point, as indicated in the brief, that's where we also learned that because 2 years had passed from the date of death, there's no way to, even if you set up an estate, there's no way to file a claim in the estate. You're prohibited from doing that under Florida law. So the next question is, well, what is the remedy for that? And the remedy that we found was that in Georgia, there is no 2-year statute limitation on that. And that since he died in Georgia, and apparently the personal rep or the executor was in Georgia, then we go ahead and go through setting up the estate in Georgia. And that's when I believe another motion was filed. And then finally, when we realized that we weren't going to be able to file it in Georgia, or it wasn't going to be accepted in Georgia, and tracked it to Indiana, then at that point, it had been so long since the time that elapsed for us to file a motion for substitution. That's when the research took place as to whether or not you really needed to, because we had served the purported PR and whether it related back to that service. And that's the basis that we've proceeded on since then.
And this relation back issue, seems to me the stumbling block is it's hard to relate back to a separate party.
Well, but Judge, it's not really a new party. It's always been the estate. We just didn't know it was the estate when the lawsuit was filed. But it's always been the estate, so there's been an identity of interest all the way through. And nothing, as I say, nothing about the pleadings, the allegations or the defenses are changed by the question of who is the personal representative. It's still on behalf of the estate. It's still based upon the actions of the deceased individual. And this is the kind of thing that just results in a claim being destroyed because of something that occurred that is unusual, which would not have occurred had we simply been advised at some point that there was a death. But more importantly than that, which we serendipitously, I agree, found out that service had in fact been made on the individual who was representing himself as the personal representative. At that point, I think that's when the relation back doctrine comes into play, and we did everything as quickly as we could to try to get service done. So there's, as I say, it's the same attorney that's representing the defendant, the same people who hired the attorney to represent the defendant. The defendant was never there to hire an attorney himself, to direct whether he wanted that attorney, to direct any of the pleadings, to answer any of the discovery. I would suggest that there never even was a valid defense made to this because they had no client. If there was no estate, they had no client. And so the whole...
Am I correct? Allstate was the insurer?
Yes, sir.
My record review suggests that Allstate was involved from the very beginning, well before the lawsuit.
Allstate, because of the nature of these cases, you negotiate with the insurance company to see if it can be resolved before filing a lawsuit. The negotiations took place over a period of approximately a year, trying to avoid the necessity for a lawsuit. During that time, 9 months before the lawsuit was filed, Allstate was put on notice by Mr. Edmondson of the death of the defendant and of the fact that he was the person or the executor of the estate. Allstate, for that next 9 months before the lawsuit was filed, never indicated, there was never any change in position, never any indication that their insured had died, and then we filed the lawsuit. And Allstate has always, even though we can't sue Allstate, Allstate has always been the real party in interest in this case. They're the ones that are benefiting from the misconception brought on by the actions of the defense attorney in defending this case, in having this case dismissed with no chance to refile it. And it's simply because Allstate, in its machinations, never allowed anyone to, or never conveyed their knowledge of what the status of the defendant was.
Mr. Newman, I've let you go way over, so if you want to save any time for rebuttal, you need to sit down at this point.
Okay, thank you, Judge, I will.
May it please the court, my name is Michael Clark. I'm here on behalf of the
I'm sorry, sir,
defendant.
could I get your name again?
Michael Clark.
Are you with Kubicki Draper?
I am, sir.
All right.
Your Honors, we are respectfully requesting that the trial court's order be affirmed and that the underlying case be dismissed.
Who is we?
Well, we is the defendant, and we've heard a lot today about the misleading actions of the defense.
The defendant is deceased.
Well, the defendant now, to the extent that any claim could be revived, would be the true estate in Indiana that was finally set up in 2012, long after the statute of limitations had run on this case.
Do you represent the person representative or whoever it is of that estate?
That's correct. There's a responsibility to the insured and now to the estate. And I want to be clear that from the very start of this case, with the initial response to the complaint, that the suggestion of death was filed. Now it was.
You've got an offer. You did a proposal for settlement.
There is a proposal for settlement in this case.
So if we were to rule in your favor, and we were to find that an award of fees is proper, who does Mr. Hessen cut the check to?
Well, the check would be most likely to the insurance company. I mean, they're the ones who are the cost of the defensive.
The offer is made on behalf of Mr. Rogers, who you know is dead.
Right. That's correct, Your Honor.
Well,
But the defense is being paid for under the liability policy by his insurer. So to the extent that, and look at the converse situation, if there is a proposal for settlement that was filed on behalf of the plaintiff, now there's an estate that could potentially be responsible for the attorney's fees, but oftentimes the insurers extinguish any...
Well, forgive me for saying so. I don't know if I would go so far as to say misleading, but this is certainly sloppy.
Yeah, there may have been
it's just sloppy.
There may have been an opportunity to quash service of process at the initiation of this lawsuit.
But I find it even more interesting that you want to get attorney's fees, and nothing is of record that would suggest that you represent anyone other than a dead person.
Nothing is of record from our perspective, from appellate counsel, because of the fact that by the time that this record was set and the final judgment was entered, we were not counsel of record. And there was two different sets of counsel below as well. And I think that part of the reason why this motion arose, we know this issue became ripe 6 months after the discovery of the suggestion of death upon the first filing of the motion, or the first motion, through the plaintiff's counsel's activities. But there was a new counsel that raised this issue as opposed to the counsel that originally answered the complaint. So I think that there was a discovery from that perspective as well. And, you know, if the court is concerned about the attorney's fee provision, you know, the motion for appellate attorney's fees is different from, I think, the issue of whether or not the trial court erred in making its decision in terms of refusing to relate it back, finding that it was not simply the correction of the misnomer, and different from the issue as whether or not there was any excusable neglect. I think that they are, I don't mean to compartmentalize.
No, I think they are separate, but as one or more of you quoted in your briefs, this is a rather metaphysical
Right. Well,
set of circumstances.
Yeah. Well, we've seen that term used in this record in this case from the court in Indiana that finally set up the estate.
Isn't it the case that even, I mean, it's after the final judgment was entered, but it's in our record, somebody at Banker Lopez and Gassler filed a motion on behalf of the defendant, Mr. Rogers, to tax attorney's fees and costs.
There is a trial court motion as well for attorney's fees. Yes, sir.
And who's the client?
Well, I'm sure that the court is aware of the tripartite relationship between insurers and retained insurance counsel. You know,
that doesn't excuse the fact that you've got to have either a live client or somebody in their representative capacity. You can't represent, a ghost.
And we can never join the insurance company in the initial lawsuit.
Right, until after a judgment. But the insurer's duty now, and has always been, to the insurer's interest, and then now to the estate's interest. So we have an estate after 2012.
I'm confused then, because looking at your brief, you filed a brief, and this is not trial counsel anymore. This is appellate counsel.
Yes,
you
sir.
filed a brief on behalf of Carl H. Rogers.
Right. Well, that's because we're attempting to affirm an order that the only entity party is the decedent. There was the substitution was denied, and our duties run to the defendant, and now as a corollary to that, to the estate. So, absent some sort of procedural mechanism where we could have moved to create or substitute in the estate.
You didn't file in this court on behalf of the estate.
No, sir, we did not. We did not, because the estate, again, the effect of the trial court's order was to dismiss the case in its entirety and to bring it to a conclusion.
But you told me earlier that by virtue of the insurance coverage, you are representing the estate.
It exists now. That's correct. It's a difficult situation that we find ourselves in.
Well, let me ask you this, and I realize that you weren't trial counsel, but how do you file a suggestion of death and then at the same time file an answer and litigate a case for 2 or 3 years as if this person who's deceased, for whom no estate has been established, is alive? How does that happen?
Well, Your Honor, it's difficult for me to answer the question as to the motivations of the trial counsel. Again, I think...
It wasn't just one trial counsel. You had Mr. Seufer, or however you pronounce his name, and then you had Banker Lopez and Gassler. They both did it.
Right, and that's true. To the extent that the issue needs to become ripe through the action of a party to be addressed through a motion, and ultimately it was the first of the series of motions filed by the plaintiff that brought it to be ripe. And we're talking about these issues of representation, and I think that the suggestion of death right out of the box shows that there really was no intent to mislead.
Okay. But, you know, if, notwithstanding the suggestion of death, you basically ignore it and continue to litigate the case as if Mr. Rogers was still alive, and in effect act as if Mr. Rogers was still alive, doesn't that at least have some capability of misleading opposing counsel about the true nature of affairs?
Well, it sounds like we're bumping up against the equitable principle of whether there's been a waiver to assert this position because of the fact that we never took any affirmative action on ourselves besides the suggestion of death, and then we litigated the case and filed.
Answer my question first, though.
Yes, sir.
Wouldn't you agree that this has some capability of misleading plaintiff's counsel about what's going on here?
And the court.
There is a potential for that. Yes, sir. And I can't change the facts that are presented in terms of when the suggestion was filed or how the issue became ripe. But
so if you concede that, why should not have the trial court recognized some sort of estoppel at work here and allowed the substitution?
Well, because estoppel wasn't argued, and because the principles that we're talking about in terms of whether a correct substitution of party can occur don't apply the estoppel principle. And when the closest we could get to an equitable principle like estoppel is the discretionary determination on whether excusable neglect was shown, and the excusable neglect argument was centered upon finding and discovering the suggestion of death, not upon and the decision was not based upon the actions of the defendant. And there's no case law that is cited in either brief, and if there is a point that both parties have missed about this idea that there is an equitable principle that would not allow us to procedurally handle the case the way that it was handled, then that's an issue that may need to be briefed. But I am not sure of it.
Why? Tell me why we could not find excusable neglect, and let's start all over.
Okay, because the excusable neglect determination was made upon the idea that the suggestion of death was misfiled. And the only argument that was presented at the trial court on the excusable neglect standard was we discovered this as we were preparing for trial. It was not presented in the form of any affidavit. It was not presented in the form of any sworn testimony. It was not presented to the trial court in any format of evidence. It was simply the argument of counsel and the idea that the pleadings, as Mr. Newman has suggested today, created this situation. And this court's opinion in Cash and Carry versus Smart talks about the application of excusable neglect in the substitution of counsel standard, substitution of party standard, and not allowing it to relate back. And this is a factual point that we can't lose sight of, is that Mr. Edmondson, the individual in Georgia who self-identified as the executor of Mr. Rogers' will, was never a personal representative, and no estate was ever established in Georgia because you couldn't meet the forum requirements of that state to establish it.
I've got to ask you, on January 23rd, 2011, there was a stipulation and order for substitution of counsel where banker Lopez and Gassler substituted in for Mr. Seufer. Robert Edmondson signs that document as executor of the estate.
Right.
How could that happen?
Well, because, again, I think that's him self-identifying as what his position is.
Well, both defense counsel, the old counsel and the new counsel, are treating this man and basically representing that he's the executor of the estate.
Right. I think that's we're talking about, I think, two different things in terms of personal representative of an estate an executor of a will. And it's
I
clear.
understand the difference.
And I think that these terms are being used interchangeably in these pleadings without an understanding of what the legal effect of them are. We know for a fact that Mr. Edmondson could not be the personal representative because there was no estate. He may have had some connection to the decedent, and he may have...
Why haven't you signed anything if he'd never been appointed?
I think, I think that, again, the decision in terms of what the substitution of counsel rule requires in terms of, notice to the person that...
Well, again, doesn't that all speak to the issue of excusable neglect?
If we're taking the position that excusable neglect arises from the actions of the defendant and not from the actions of the plaintiff. I mean, the problem...
And wouldn't it have been a relatively simple matter for somebody to pick up the phone and call the plaintiff's counsel and say, hey, this guy's dead?
Yes, Your Honor, and I'm very sensitive to this as well, as someone who, we're talking about non-record matters. We're talking about what occurred at a mediation. We're talking about what happened during this period of time. And the simple fact is I'm not going to make a representation to this court because I wasn't there and I don't know. But there's no proof in the record that that phone call that you just suggested never occurred. I don't know that it did or it didn't. But we're raising these hypotheticals that are very pointed, and I can't disagree with that. I can't disagree that a phone call like that could have been made. But from the defendant's perspective, the suggestion of death is the appropriate pleading to file.
Yeah,
and it was
but
done at the inception
after
of the
the
case.
suggestion of, that's where it should have ended. It should have ended at the suggestion of death, because if the man is dead and there's no estate, then the burden's on the plaintiff to get somebody appointed and get them substituted in. You don't go on and file answers and, respond to requests for admissions and go to mediations and act as if there's nothing wrong.
Again, I don't know. I don't know what occurred. And the
you
court
know that
can't know what
occurred.
occurred. Well, but at the mediation, since we're, and I don't mean to be flip, but I don't know that at the mediation, which is supposed to be a confidential settlement conference.
Well, leave the mediation out of it. Why do you file the answer? Why do you do anything other than file the suggestion of death?
Because the pleading is required within the 20 days of the service. Again, I may have, you, the court, Mr. Newman, myself may have handled the case differently in terms of the service of process issue. We didn't bring that issue to this court because it was certainly not preserved. There is no crystallized issue that would allow us to argue service of process. So a different pleading may have come from a different lawyer or defense attorney's office. I agree with the court on that, besides the suggestion of death. I agree with that. And there's what I'm trying to deal with is this record and what occurred, what the trial court decided, and whether or not the trial court's decision was correct. Almost all of the principles that we've talked about, or the court is very interested in, are principles concerning equity and estoppel, which were not generally argued below and were not the basis of the trial court's ruling. But I know that this court needs to be concerned with the entire case file, and in terms of needs to be concerned with the entire result, so to speak. But under the law that we're dealing with, and particularly Cash and Carry versus Smart, where there is no proof of the excusable neglect, and Johnson versus Taylor Rental Center, which is another decision of this court that essentially says that you cannot substitute in a party, which is again the motion that was at issue, if it is, even in the Johnson case, a franchisor-franchisee relationship, which is why I tried to drive home the point of what the trial court found, which is we have a non-existent estate in Georgia when the case was at its inception, And then in 2012, we finally have an estate. So there is no original estate to relate back to. There is no original estate. And we know that because of the findings of the Georgia court and the failed efforts to set up an estate. So with that, unless the court has any other questions, I will conclude. Thank you, Your Honor.
Thank you, Mr. Clark. Mr. Newman, I mistakenly let you go way over your time, but since that was my error, I'll give you 2 minutes for rebuttal, sir.
I don't even think I'll need that, Judge. I just want to point out that the order dismissing the case was based upon the failure to meet the standard or file in accordance with Rule 1.260. Clearly, the failure to file the motion with regard to 1.260 was based upon the perceptions that would normally come from the actions of the defendant by, as you noted, filing the answers as if the defendant was still alive and viable. And that is, the court below ruled that did not establish any excusable neglect, that there was no evidence to that effect. Well, the evidence is in the pleadings and the date of filing of the pleadings. There is no sworn evidence because this occurred over a 2-year period. There's nobody that really individually can say this was done or this was not done, but the pleadings are in the record, and they do establish that the order that they were filed in. Thank you.
All right, thank you both. Unusual problem. All right, we'll take up the last case, which is Lutz versus JDE Florida LLC.